All right, all right. Good morning, good afternoon, good evening, wherever you are attending this program from. As I've already said, this is one of Africa's law students' ultimate objective that we are living up to. Today's program is premised on the topic entitled Legal Status of Life in Relationship with the renowned legal luminary from India in the person of Bhawna Gandhi. He's an advocate of the Delhi High Court in India. And now, before I proceed on, and then also to invite the Secretary General of the African Law Student Association to introduce our honorable guest for advocate for this program, I would like to first of all bring to notice what African Law Student Association is into. If this is the first time you are attending our webinars, I would like to brief you in a gist on it. So ALSA, African Law Student Association, here in after referred to as ALSA, was initially called African Law Students, and it was first established by law students as an online professional resource community in 2013 with the vision of providing African legal luminaries, lawyers, and law students latest and comprehensive legal education and the happenings in the legal world. By the year 2015, it became well established with a base of many law students and lawyers all over the African continent. The organization published its first African Law Journal in the year 2015, and it was published over 7 volumes of the journal since then. And as we speak now, we are still calling for the next journal to be published, and we are calling for research papers from law students, lawyers, and what have you. So ALSA is registered with the Corporate Affairs Commission in the Federal Republic of Nigeria. And so if you talk about legal status of ALSA, we are legally recognized. So we are a non-profit, non-partisan and umbrella that brings law students together so that we can share our various legal systems, because we believe that we live in a global village and barriers shouldn't be an issue when it comes to legal education. So we have physical presence in over 20 African countries. We have over 10,000 members across Africa, and we have over 90 ambassadors across Africa in different universities. So basically, this is what African Law Student Association do. And we are so much glad for having each and every one of you here. To follow us, we are on Facebook as African Law Student Association, on LinkedIn as African Law Student Association, on Twitter as African Law Student Association, and also on Instagram as Africa.Law Student Association. So this is what African Law Students have to offer. You are most welcome once again to the African Law Student Association webinar for this particular evening program. And once again, to welcome our guest for today's program, who is Advocate Bhawna Gandhi from India, to just highlight, some of the critical points that you ought to know so far as you're attending this program. The advocate for this program is practicing in India, Delhi High Court since 2019. Presently, she is associated with the Delhi State Legal Services Authority as a research assistant, representing India as a global youth ambassador for the education until 2023, national member of Anti-Sexual Harassment Council of WICCI-Advisor to Indian National Bar Association section for law students. She practices in domestic violence and sexual harassment matters. She has vast experience of working with top-notch lawyers, law firms, CBI, police, and other government organizations with special impetus on criminal laws. Our facilitator for today's meeting, while at Law College, she has been a recipient of Achievers Awards, Leadership Awards, and various other academic awards. In 2018, she became the first ever female chairperson for Indian Bar Association's sector or section for Law Student Association. So this is a brief biography of our facilitator for today, Bhawna Gandhi. I'm very sorry, advocate, if I don't pronounce your name correctly. So thank you so much, and we are so much glad for having you. My name is James Samporekun, Vice President for African Law Students Association, and we welcome you for this webinar. Thank you.
Thank you so much for such a warm welcome and such a great introduction of mine. And I would just like to clarify, can you see my presentation? Is it visible? Is my presentation visible?
No, please no. I think.
Okay, just also just could you just make me the presenter?
Sure. Let me do that.
Also, I have sent you a message on personal chat. If you could just do that, it is requested.
Sorry.
I have sent you a message on Zoom chat.
Okay.
Can you see that? Can you see my message? Could you please follow that instruction?
Okay, please let me check that. Let me check that, please.
Sure. Thank you so much.
You're most welcome. All right, so I've made you the host. I don't know if that will be able to you are sharing the screen, but I'm seeing it's very small. That's the issue. I can see you are sharing your screen, but it's very small. Okay. Punet Kuma. Okay. Wow, I don't know. I don't know how we can. Hello? Hello?
Mr. Vice President, can you hear me?
I can hear you. I can hear you. You're loud.
So I have removed that person. Thank you so much for giving me the controls.
Yeah.
And are you able to see my screen?
Yes, you're most welcome. You're most welcome. Please.
Are you able to see my screen? Is my screen visible?
Yeah, I can see you.
My presentation.
You can
see.
I can't see your presentation.
You can see me, but you. Okay, but I'm sharing my screen. Just wait. I'll try to share this once again.
Okay.
Now?
Yes, that's cool. Yeah.
You can see it?
Yes, I can see it.
So I'll just try to can you see it moving?
Yes, I can see it moving. Maybe you can enlarge it a little bit.
I have done it of the maximum size. Just a minute. So only you have to do it this way, that in such a way that my video and my presentation are visible. I think only you can give those controls, or either you can present it that way.
All right, that's fine. As we move along, I'll work on that. Thank you. Why is this still not? Now, it is okay now.
It's okay now?
Yes, yes, please.
All right. So should we wait for more participants to join, or shall I start?
Yes, you can. We can do that, please.
You want me to wait?
Yes, please. Yeah, you are in control unless otherwise required. Thank you.
All right. So for how long should we wait? 5 more minutes?
For the entire presentation?
No. I am asking you. Are you expecting some more people to join in? So should I wait before starting the session, or should I start?
Yes, please. Please let's wait for at least 3 to 4 minutes. We expect to see more people joining.
Yeah, sure. You can just send out reminders to people, and then I am here only.
Yes, okay, please. Thank you so much.
Thank you.
All right. Hello. Hello, advocates. Hello.
Yes. Hi.
Yes, please. The challenges and most of our people are facing network challenges in joining. So I think we can kickstart as and when they're able to come in. We just take it from there. And then better still, so far as we are recording, we are going to make it available on all our social media platforms, as well as we are also trying to stream live on our Facebook page. So I think,
All right. Yeah, I have no issues. I
sure.
can start whenever you tell me. Whenever you give me signal, I'll start.
Yes, please.
Also, I've made you the co-host.
Yes, please, we can start.
Okay, so we can start.
Yes,
All
please.
right.
Thank you.
Can you see me?
Yes,
Can you see my video?
yes, please. I can see.
Okay, so hi, good evening, everyone. This is Bhawna Gandhi, and I'm an advocate practicing at Delhi High Court, India. Delhi is basically the capital of India, and I have been practicing from the past 2 years. And ever since the COVID-19 kicked in, so I started working with the legislative department of the national capital city of Delhi. So currently, I'm working with the Delhi Legislative Department, the Delhi State Legal Services Authority in the capacity of a research assistant. So my role, just to give you a brief background of what my work role exactly there is. So in India, we have an act called as the Legal Services Authorities Act 1987, which provides that no person, no citizen of India should be deprived of the legal aid or legal representation because of lack of resources, because of any kind of social or economic backwardness. So we are working on the behalf of the government to provide free legal aid, free legal representation to all those people who are arrested, to all those people who cannot afford the legal services. And these services are being provided at all levels, not just in the court, also beyond the court. We are providing such services beyond the court. And besides just working on the legal representation and legal aid, so my work is also to provide strategic legal awareness and strategic legal aid, in the sense, if people wouldn't know that they have this facility of availing legal aid through our office, how would they avail this facility? So we are working on organizing pan India, pan country, state level, district level, village level programs, so that people are sensitized, people know that yes, they have certain constitutional rights, and they have statutory rights. So this is uh, can we mute? Yeah. All right. So I am working in the field of victim assistance as well, and also I'm working for the prisoners for their rehabilitation. I'm working for getting employment, counseling, and other facilities for the prisoners also. So this is a brief background of mine. And besides this, I have recently been appointed as the legal facilitator for this esteemed African Law Students Association. And I must say, I'm really privileged and grateful to all the members to have invited me here, to have me here and speak on this pertinent topic. So, Mr. Vice President, should we start with the session now?
Thank you so much for that wonderful introduction, Advocate Gandhi. Yes, please, we can start. Thank you so much. Yeah.
All right. So today we'll be talking about the legal status of live-in relationships in India. The reason I took up this topic and why we should be discussing this is because, long time ago, legal such live-in relationships, they were in force, and people were actually, they were actually having some such kind of living arrangements wherein uh, outside marriage, they used to live together. They used to have each other's company, but because of the societal pressure, they did not come out. Now, with the liberalization and with the more west, we are moving more towards the westernization. So now, what are we seeing? There is a shift that people are becoming more open. They are becoming more liberal about their personal lives also. So now that's why we see that there is a huge influx of these cases. these live-in relationships. So I will just make you skim through the presentation. So this is briefly what are we going to discuss today. What what live-in relationships are, what is the legal status of these live-in relationships, what are the rights of the live-in partners, and what if while you were in in a live-in relationship you give birth to a child or two, so what are the rights of those children, and then what are the remedies, and some comparative analysis with some other countries. Yeah. So the meaning of live-in relationships, first of all, live-in relationship is nothing but an arrangement whereby two people are living together without the foundation of a full-fledged marriage, but they have, some kind of arrangement wherein they are, which is in the nature of marriage only. Though they are not married, but that relationship that they have, it is in the nature of marriage. So there is a difference between being married and being in a relationship which is in the nature of marriage. Essentially, in a live-in relationship, these two people should be, rather I should be saying they must be major. So every country has, for instance, a legal age for marriage. In India, we have two different ages for male and females. For males, we have 21 years, and for females, we have 18 years. And also, I would like this webinar to be interactive. So I would request all of you to please switch on your videos so that, I can also see you all and I can interact. And, if I feel like having a discussion in between, so I can ask you. So what's the legal age for marriage in your country? Anyone? Please feel free to discuss. We are only here to discuss and share ideas and discuss about the legal systems that we have.
Yeah, so advocates, please can you ask the question? Can you ask the question again?
Yeah.
What is the legal?
Yeah. So what is the legal age of marriage? What is the legal age for marriage?
Oh, okay.
After which, after which a male or a female can enter into a marriage legally.
Okay, that's good.
Anyone? I think someone has raised hand. Could you please, Mr. Co-host, could you please admit this person and allow him or her to speak?
Okay. Please go ahead, Rayan from Uganda. Please go ahead.
Sorry, are you asking something?
Rayan, go ahead.
What I'm trying to say, what I'm saying is, according to the Ugandan Constitution, for the stipulates that
I think there is some network glitch from your end. I am not able to hear you properly.
Yeah,
I'm sorry.
Yeah, I think that's same over here. But
you say,
no, I can't. Can you repeat yourself?
Mr. Vice President, why don't Mr. Vice President, why don't you answer?
All right. If I heard him correctly, he's saying that in the Ugandan laws, the maturity age for marriage is 18. And I think it's similar to that
18.
It's similar to that of my home country. I come from Ghana, and with the maturity age, it is deemed that once you attain 18 years, you have that you have the consenting knowledge to consent to you being married to a different person, or a man or a woman. So that is it. 18 years of age, you are deemed to be at maturity.
Okay, all right. So this is something interesting because even we in India we have 18 years as legal marriage for females, for girls,
Mhm.
and for males we have the legal age as 21 years. So this brings me to the very first important essential of a live-in relationship. That for a live-in relationship to if the live-in partners want that they should be having rights to each other's property, or they want to have the right to alimony, right to maintenance, and other rights. Those would only flow if you both are in a legal age of marriage. Though you are not married, but your age should be, you both should be major as per the law of your own country. Then the other important essential is that none of the partners should have a spouse living at the time of this relationship. For instance, if there is, I'll just give you an example. For example, now there is a man X who has a wife living, and he enters into relationship with a woman Y. So this relationship, it's not just morally wrong, but in India this is also punishable. So if you have a wife living during the lifetime of that marriage, or during the lifetime of that of your wife, so until and unless she's not dead, you have not divorced her legally, if you have got if you're not legally separated, you cannot marry someone else, and also you cannot have any other's company, because in that case the status of that female living partner, it would be of that of a mistress as per the Indian judgments. So that would she would be accorded the status of a mistress. I will just discuss in detail these things. So I will just skim through the essentials once again. So what is live-in relationship? Simply put, it's an arrangement whereby two unmarried people of legal age, they are living together, and they are living together in a shared household, and they are living together as husband and wife, but they are not exactly husband and wives.
Oh, okay.
All right.
All right. So can I ask a question?
Yeah, please.
All right. So how do you draw the distinction from the definition I've just given in your previous slides? What is then the distinction between that and cohabitation?
Yeah. So you want to know what is the meaning of cohabitation?
Yeah. What is there any difference between the life in relationship, you'll be people living together,
Yes.
as well?
Yes.
Is there any difference between that and
Yeah.
cohabitating?
Yes. I'll just tell you that. So in India, whether you are married or not, all I'll just give you a background. Okay, I'll just take you to the background of how personal laws in India work.
Okay.
So in India, which set of laws are applicable to you, this is determined, this is ascertained by which religion you belong to. For instance, in India we are a home to so many religions. This is the beauty of India, unity in diversity, that we are a home to so many religions: Hindu, Muslims, Christians, Sikhs, Buddhists, Jews, and so on, right? So whenever for instance I am a Hindu by birth, both of my parents are Hindus, so I am governed by Hindu marriage act. If in case I want to marry, in case I want to divorce, so Hindu marriage act would be applicable on me. Now when I'll bear my offsprings, when I'll give birth to children, so they will also be governed by the same laws. And in case I want to adopt anyone, I want to be the guardian of any children, so in that case Hindu laws again, in the form of guardianship or maintenance, they would be applicable to me. So likewise we have separate sets of religions, we have separate sets of laws for every religion. Then we also have secular laws. For instance, if religion of any person is not known, suppose if he's an orphan, we don't know from which religion he belongs. Or for instance, if any person doesn't want to be governed by his personal laws, personal set of laws. Now, if I say that I don't want to be governed by the Hindu law, then our legislature has also enacted special and secular laws for us. For instance, we have for marriage, Special Marriage Act. We have Indian Divorce Act. So these acts, these laws are applicable to all. If you voluntarily consent that yes, I want to be governed by this law, and you are a citizen of India, yes, you can be governed by this. So this is how personal laws work in India. All right. Now, when do you say that that any two people are married? So we have our Hindu Marriage Act, the Section 5 and Section 7 of it. It clearly lays down the essentials for a marriage. Firstly, we have some legal formalities. Again, the legal formalities are same. The parties should be major. Then none of the party should have a spouse living, and then they should not be in consanguinity, or they should not be in any kind of close relations with each other. So, and also none of the parties should be mentally unstable at that time. So we have certain legal formalities, and then we have the religious formalities. So, for instance, I being a Hindu, in Hindus, how the marriage take place. So we take seven rounds across the holy fire, and we read out a lot of there are a lot of customs and all. So if I am performing that marriage according to the custom, only then I will be accorded the status of of being a married couple.
Okay.
For example, if you are Christian, so you might be having a church wedding, right? So once you follow that customary process which is prescribed by your religion, and also your that customary marriage is also conforming to the legal formalities, only then you say that you are a married couple. All right, so this is what being a married couple means. And what is a live-in relationship? Live-in relationship is nothing but when you are in the nature of marriage. I'll just list down some parameters, and then this will be more clear to you that whether two people are in a live-in relationship, or if they have a casual relationship, or if they have a marital relationship. So you will be able to strike good differences in that. I'll just bring you to that aspect also.
Yes, thank you so much.
So also, when we talk about the legal status to these anything for that matter, these legal statuses and these things, these flow from the parliament. So to if there is any act, or if there is any activity, for it to be a legal activity, this thing should flow from parliament, right? So some countries, for instance, United States, Canada, and only some states of United States, not whole of it, United Kingdom, there they have specific laws which govern the rights and the liabilities of the live-in partners. Whereas in countries like West Africa, to which Nigeria is also a part, then India, where I belong. So these countries do not have full-fledged laws on this. They do not have full-fledged, statutes or acts related to this. But what progressive thing the organ of government has done is that we have come up with judge-made laws. What are judge-made laws? Suppose if any live-in couple has knocked the doors of the court, so there the courts have provided them with good remedies, though there are no laws which are existing at that time, but the court is trying to fill those legislative gaps. So this is how legal status is accorded. Now coming on to the parameters. Now this will help you in understanding what are exactly the essentials of a live-in relationship. So firstly, there is a domestic arrangement Domestic arrangement, by domestic arrangement, what do I mean? By domestic arrangement, I mean that the girl and the boy who are alleged to be in a live-in relationship, they are living in the same house. They have a domestic arrangement, similar to that of a husband and a wife. All right. And for instance, now, if one can say, um, if any casual relationship, if any, if you're spending the weekends with any particular person, or if you have one night stands for that matter, does that also count as live-in relationship? So that is a big no-no. For a live-in relationship to be a valid legal relationship, it has to be a domestic, there has to be a domestic arrangement. And besides a domestic arrangement, there should be a cohabitation. Now, this brings me to what cohabitation exactly means. Cohabitation is when you both have right to each other. Now, this right over each other, this of course extends to each other's body. So this means that you have sexual relationships between each other, but your relationship is not just restricted to that. You also have right to each other's company. You also have some intimacy. You also have emotional and some other kind of attachment towards each other. If it's purely sexual relationship, it is not a live-in relationship. I repeat, if it's purely a sexual relationship, it is not a live-in relationship. And for cohabitation to be a valid one, it must follow some kind of emotional, needs also. Then the duration of the relationship. Now, if, for example, two people have been living together for a week or 2 weeks or for say a month, so can we knock the doors of the court and say that we are a live-in couple and we want to, for example, if the woman wants the right to claim maintenance. So does this period sound reasonable to you? Of course not. For a legal relationship to be a valid one, the cohabitation should be for a significant period of time. Now, this significant period of time, I cannot tell you, there's no straitjacket formula to ascertain that. It may be a few months, it may be a few years also. Interestingly, in India, in the very first case of live-in relationship, a couple was living together for almost 50 years. 50 years. This was the first ever case that came to India, wherein a couple was living together, not as husband and wife, but rather as live-in couples for almost 50 years. And the courts, they they ordered in their favor, and the court also ordered maintenance for the woman in that case. So it is not that the duration always has to be this long, but the duration has to be seen in the lights of the facts and circumstances of each case. And the thing that we always say is that what matters is that what is the intention of the parties. If the parties actually intend to be together, in that case, yes, your conduct, your intention, your volition. So these things are going to determine what kind of relationship, what kind of equation you have. Then a very important aspect is the financial arrangement of the couple. So if the financial arrangement of couple is such that a husband and wife would have, for instance, if the wife is, for instance, my bad, not the wife, the female partner, if she's paying for your EMIs of your car, if you are paying for her other expenses, if you both have a joint account in your name, if you both have bought a car in your name, and you both are, you people have such financial arrangements which resemble to that of a married couple. All right, it's not that just one person is bearing all the expenses. So also this just to strike a distinction here also, there are also instances where the woman doesn't want to work. For instance, if she's a housewife, so in that case, she's bearing all the responsibility of the domestic work, and the husband is earning. So in that case also, though the financial arrangement is such that the husband is only carrying out all the expenditures, but because they have a good division of the domestic arrangements and the financial arrangements, so this would also come under the category of the live-in relationships. Now, pooling of resources, again, this is the same thing. If you are pooling each other's resources, in that case, that is a valid proof of you being in a live-in relationship. And now comes the most essential, the most pivotal essential of being in a live-in relationship, and that is that the society, who comprises of the society? Your neighbors, your friends, your family, your colleagues, people around you know that you are in a relationship with this XYZ person. If your relationship is of a very private nature, if it is of a secretive nature, that is not going to count as a living relationship. And the society should the society should perceive you both as either husband and wife, or a couple which is together for a good time. It's not that you are going to the court to seek redressal for something, and no one in your society knows that you both were together. So the court is not going to allow your application in this case. All right. So these are roughly the parameters that the courts in India have determined to ascertain whether a relationship, if it is a live-in relationship or if it is a casual relationship. Mr. Vice President, is this clear now? Or if you want further clarification, please let me know.
I think you've made everything clear, very well articulated, and is understood.
Okay, thank
Yes.
you. If anyone has any questions or anything in between, you can just raise your hand, or you can just unmute yourself. Let's be interactive, and feel free to ask your queries. Feel free to discuss what is the law in your country, in your state, or for that matter, anywhere in the world. All right. So now coming on to the next part. Now, why are we even insisting that these essentials should be met, or the legislature should pass an act for granting legal status to these couples? Why is it so? Because without any burden of marriage, without any burden of these marital obligations, this couple is anyway living together happily. So what is the need? The need is that the courts also want that some kind of matrimonial rights, some kind of maintenance rights, property rights, custody rights. So these rights should flow from such relationship. Now just imagine if you are in a live-in relationship, and you have begotten a child, and then you both are separated, then you both want to part ways. What would happen to that child? What would that child be a legitimate child? Who is going to maintain it? Who is going to, is he going to inherit any property? So there are a lot of obligations that flow from such relationships. This is the reason that the courts these days, they are recognizing these relationships, and they are ordering in favor of the children who are born out of such relationships, and also to the aggrieved partners. So this is the reason why some countries have also come up with the laws, because they want to have a good rights and duties framework within which the couples can invoke, and they can take recourse from the court. Now, what are the remedies in India? Now, India as you know, India is, though we are a developing nation, but still we have some kind of traditional notions whereby women are, even for that matter, men, they are expected to marry with the choice of their family. And the other thing is that you should attain majority before you get married. So what people these days are doing, before they attain majority, or if they want to, marry someone other than the person whom their family wants, so they either run away with them without informing their parents, or what they do is they enter into live-in relationships. In India, your right to life, which is guaranteed to every person by the Constitution of India, it expressly says that every person has a right to marry a person of his own choice. So doesn't matter if your father doesn't like any person, doesn't matter your mother doesn't like any person, or any XYZ person doesn't like you have a right to marry a person of your choice, out of your caste, out of your religion, out of your country also. Once you have attained majority, you can take decisions on your own. This is a very important right which every person in India has. Now, despite having such rights, there are a few couples which come to the court and they seek protection from their family at times, because the incidents of honor killing. Does anyone of you know what honor killing means? Honor killing?
No, please, can you explain?
Yeah, okay, I'll just tell you. So, honor killing is an offense whereby you kill any of your acquaintance because you think that the act that that person has committed has it has brought you to a disrepute. If you have been dishonored, if your standing in the society has reduced. For instance, if any yeah, okay, so if anybody's child, if he or she has committed bulgari, you know, if he has committed bulgari worth millions and billions, all right, and his parents get to know about this, and his parents are also some big shots, and they are so furious at him that they are saying that you're this particular bulgari, your this act has brought us to disrepute. So if they are murdering him, if they are murdering their own child, so that would count as honor killing, because that killing has been done with the intent, not with the intent, I would say, but rather in a rage that you have dishonored us. You have brought this family, you have brought the name of your parents, your family to disrepute. So these are honor killings, the killings which
Sorry. I'm really sorry for that. I'm trying to mute. Yeah.
no, perfectly fine. So these offenses are known as honor killings, when you're killing someone because you think that the particular act of someone has brought disrepute to you or to your family or to someone you know. So that counts as honor killing. So in India, there was a time when if a person used to marry outside his caste, outside his religion, so that was not considered, that was not perceived well by the family members of that person. So the instances of honor killing, they were prevalent. So how did the courts react to this? Because as per the courts, every person has a right to marry a person of his own choice. But here are the parents of the children who don't want their child to be married to anyone outside their caste or anyone outside their religion. So such couples, they used to seek the jurisdiction of the court. They used to invoke the court's jurisdiction to provide them with police protection. So what happens is, if you are a live-in couple, or if you think there is any kind of risk to your life, so what you can do is you can approach the nearest court, and the court will ask the police to give you protection, even from your own family or any person, if you think that if you have any threat to your life. So this is the one of the remedies that couples in India they have, that they can approach the court and they can seek protection from the police if they think there is any kind of threat to their life. If this protection is refused, or if they want to invoke any other fundamental or any statutory rights, so they can also invoke the writ jurisdiction of the court. When I say writ jurisdiction, does any of you know what does a writ means? WRIT, writ.
Okay.
Anyone can raise your hand.
Okay, so with let me say this, with the writ invocation or invoking a writ jurisdiction, I think it has to do with the initiating of a court proceedings. All right.
Yes, you're absolutely right. So by invoking writ jurisdiction, it means, so see, you have certain fundamental rights. Your constitution grants you certain fundamental rights, constitutional rights also you call it. So in India, we have certain fundamental rights, and if any of our fundamental right is infringed, which means that if it is violated, whether by private person, whether by any state, or any other organ of the state, so any aggrieved person whose right is so infringed, he can approach the court. This is such an important right that this the very right of approaching the court if your right is violated, this is known as the heart and soul of the Indian Constitution, because a very beautiful right flows from here, that if any of your fundamental right is violated by the state, you can invoke the writ jurisdiction. So what application you file in the court is, that is the writ jurisdiction. And like every court has its own jurisdiction: criminal jurisdiction, civil jurisdiction, family jurisdiction. So likewise, the Constitution of India, it provides a separate mechanism for writ jurisdiction. And the constitutional courts, that is the High Court and the Supreme Court, they have the power to enforce your fundamental rights by issuing appropriate orders in case any of your right is violated. So this is the meaning of writ jurisdiction. And this writ jurisdiction, these are only dealt in by the High Court and the Supreme Court of the India. So this is what writ jurisdiction means. Now coming on to the next thing. Yeah. So in India, there is no act which per se covers live-in relationships. Like I will just tell you about United Kingdom first. So in United Kingdom, the live-in partners, they are governed by the Civil Partnership Act of 2004. In 2004, just a brief background of this act. In 2004, the United Kingdom, they came up with this act, Civil Partnership Act of 2004. Essentially, this act was enacted to provide legal status to the same-sex couples, LGBTQ community. But later on, by an amendment, this act is also now applicable to the heterogeneous couples, that is a male and a female who are not married but they are living together, if they are in a live-in relationship. And what is the purpose of this act? Why was there a need to even codify such a relationship? Because the United Kingdom government, they thought that such relationships are very much prevalent, and just because these couples, they have not done a formal marriage, they do not want to deprive that couple and also the offsprings of the rights that would flow from a valid marriage. Though you do not have the perfect rights, but at least they want to give the courts and the legislature, they want to give you some kind of, rights, so that you are not deprived and you are not in a total state of destitution in case of separation. Now, what is the purpose of this act? The purpose is to grant legal recognition. So, in this act, if the live-in couple registers with the appropriate authority there, so they will grant you a legal recognition. You will be entitled to all kinds of health, all kinds of matrimonial, benefits. The same condition that I discussed in the start of the lecture, that the parties must they must be above the age of 16. Why? Because the legal age for marrying in United Kingdom, that is not 18, but rather that is 16. So these are the same three conditions that this act also prescribes, that the couple should be, they should have attained majority. They should not be within the prohibited degrees of relationships, and they should be unmarried. So United Kingdom is way ahead of us, and I would say this is one of the best practices that other nations should also follow in years to come. For that matter, even India, Nigeria, and other countries of South and West Africa. So this way, we are codifying the rights, the duties of partners towards each other. And just imagine the plight of a woman who say has who has got not impregnated, for say if she has been uh, if she is bearing the child of the live-in partner, if she is pregnant with the child of that person, and what if that person has left her, if he owing to her pregnancy or any xy reason, if he wants to part ways with her, then who is going to maintain that woman, who is going to look after the child uh, who is in her womb? All right, so we actually have to codify, we actually have to provide for some kind of mechanism, so that the partners and also the next generation which is flowing from these relationships, they are not left in a state of destitution, they are not vagrant. Being vagrant or being destitution means that there should be someone to at least maintain that person until that person starts earning or that person's attained majority. So there should be at least someone. All right. So I'll just take you back to the system that we have in India. So as told to you earlier, like United Kingdom has a full-fledged act which codifies that this is the right, this is the duty of the couple, of both the partners. Sadly, in India, we do not have any such act which even recognizes this. But a positive, or you can say an affirmative action was taken by the Parliament of India in 2005. So what they did, they enacted an act in the name of Protection of Women from Domestic Violence. I will just write it down for you. So that is Protection of Women. Is it visible? Yeah. So the act is protection of women from domestic violence. So if a woman has been subjected to any kind of physical, verbal, emotional, sexual, any kind of abuse from her partner, so she can file an application, and she can seek protection from the court, and also she will be entitled to residence, she will be entitled to protection, she will be entitled to the custody of her children if they have children. So the welcome step that the government of India took was that earlier this act provided that such protection would only be granted to married couples. If your husband has subjected you, if you are subjected to any kind of domestic violence from the end of your husband or anyone in domestic relationship, only in that case. But this act then provided that also if a couple has a relationship in the nature of marriage, this is a beautiful phrase that this law uses, relationship in the nature of marriage. So this act provided that besides providing protection to the married woman, if there is any woman who is in the nature of, if she's in a relationship in the nature of marriage, relationship in the nature of marriage, this infers the live-in relationship only, and such a woman has been subjected to any domestic abuse, any kind of physical, verbal, sexual, any abuse from the end of her partner, she can approach the court. Now, this was the very first time that any law in India provided for any such affirmative right, and various various females have used this particular provision to seek protection from the court, because this domestic violence, it's a pertinent issue across all borders, across all nations, across all societies. We all know. And so this was a welcome step. But beyond this, in Indian laws, we do not have any full-fledged bifurcation of rights and duties of the living partners. There have been so we have law commissions, we have judicial committees, the judicial committees are formed regularly to check whether the, just a minute, I am getting a message that how much maintenance is given. Okay, I will come to that point also. Miss or Mr. Elna Kumalo, we will come to that aspect also, how much of maintenance is given and what is the procedure for granting maintenance. This is a really interesting question. We will also come down to this. So in India, just to check if any law needs any revision, any review. So we also form judicial committees of retired judges, of lawmakers, academicians, who check and who recommend then the changes that are supposed to be done in the law, in any particular law. So such judicial committees have recommended that wherever maintenance provisions are provided, in those provisions, the word wife should be substituted, or rather it should be interchanged with the phrase that woman who is living with the man like a wife, or relationship in the nature of marriage, for instance. So such a language or such a phrase should be used so as to make it more expansive and cover also the women who are not per se legally married but are in the legal relationship. So this is the exact framework that is being followed in India. And one important aspect that is that has recently come up before the courts of India is whether a person whether a person who is legally married, he's not divorced, he has a wife living, he has not filed for divorce. For that matter, even if he has filed for divorce, his divorce petition is pending. And or if he has a spouse living, she is not dead. Now, whether such a person can enter into a live-in relationship, and whether such a couple can, seek protection from the court. So I would like any one of you to answer to this. What's your take in this on this? Whether a married partner, whether a person who is married to someone, should that person be given protection if he is entering into a live-in relationship with another person who is unmarried? To put it into simple words, there is a person in a relationship who is married to someone else, but he's in a relationship with someone. So, do you think this is right? And should this couple be accorded some kind of protection? Or do you think such relationships are not morally or socially right and no protection should be accorded to them? Any one of you?
So, sorry. Okay. So I was thinking that the law should be broad enough to accommodate situations like this. But if you look at the fact that marriage is rooted into social circumstances, and that the need for the law to regulate the institution of marriage itself and relationships themselves, I do not think that people would argue that granting protection to such relationships would alter the sanctity of the marriage institution. I mean, depending on whichever way you look at it, I know that laws are basically dynamic, and what applies to India might not literally apply in South Africa, for example. So granting protections to relationships like this should largely depend on the moral values that prevail in the society from jurisdiction to jurisdiction.
Perfectly answered, I would say. And in my opinion, that if anyone wants to have a live-in relationship besides being in a marriage, so that person, anytime he has this option of, filing a divorce petition, he can file for divorce with the wife, and then he can enter into as many relationships as much he wants, isn't it? Because if the courts, or for that matter, any act comes up which says that, which legalizes any such relationship of a married man with an unmarried woman, so this is seriously going to hamper the wife of that person, or for that matter, even if a married woman is entering into any such relationship, so this is going to hamper the life of the legally wedded spouse, the husband in that case. Why am I saying this? Because there may be a case wherein you have begotten a child. You have begotten not just one child, or maybe two or three from that marriage. So, who is going to look after them? Who is going to look after that wife or that husband of the first marriage? At least you should file for divorce if you think your marriage is not working out. You file a divorce, and then you enter into any relationship, or you enter into any marriage, right? So even in India, what is happening presently is that the high courts, this matter has not come up before the Supreme Court, Honorable Supreme Court, which is the apex institution in India. And this has come forth before the high courts of various states, and the high courts have ordered, they have given diverse opinions on these things in the light of the facts and circumstances of the case. In some cases, they have granted protection, citing that fundamental rights, they outweigh any other thing. They say that you have a right to live with a partner of your choice, and anything or all and sundry, whatever that is coming in the way of your fundamental rights, sorry, we cannot allow that. So they have adopted a liberal approach. Some of the high courts have approached, shown a very liberal approach towards such relationship, and they have said that we are going to give protection because both the parties are major and they know what they are doing, and what kind of equation they have. They have, contemplated, and then only they have entered into such a relationship, and we cannot disallow such relationships. On the other hand, there are some high courts have, they are not granting protection, citing that such, if such relationships are allowed, so they say that this is going to disturb social and the moral tenets on which a society is built. So I think that in such cases, decision should be made strictly on the basis of facts and circumstances, and one must, infer the, I would say, intention of the parties from their conduct. Now, for example, I'll just give you an example of a recent case which came up before India in one of the high courts. So there was a case wherein a person had filed for divorce with his first wife, and he was in a live-in relationship with the other woman. And owing to COVID, because the courts were not functional for some time, so his divorce petition was pending, and meanwhile he sought the court's protection with respect to the live-in relationship. Now in this case, the court said that if we see that that person had no intention to harm the rights of the first wife, he had filed for divorce, then his divorce petition was pending, and also in one of the observations, the court had seen that the previous marriage, it had broken down irretrievably, which means that there were nearly zero chances of reconciliation between the parties. So in this case, the court allowed for the protection. But there have been cases wherein the some partners have their legally wedded spouses living without any divorce petition pending, without any other court proceedings. They seek the protection of the court. In these cases, the courts have come down heavily on them. So the courts say that you cannot, in the name of the fundamental rights, you cannot, just harm the, or you cannot, violate the rights of the first wife, because she also she has a right to your company. She has a right to be maintained by yourself, by you. So, fundamental rights or such kind of liberalism, it cannot come in the way of the rights of the first wife. So, to sum up this, the high courts have differed in their opinion, and on the basis of the facts and circumstances only, they are deciding such matters. Now, I would just a minute. Yeah. Just a minute, my system just got hanged. Yeah. So, one of the, I would just briefly discuss two provisions of law other than the protection of, I have just discussed with you the Protection of Women from Domestic Violence Act, and I would just, discuss two sections of the Evidence Act which are used by the parties which are often used by the parties to ascertain whether a relationship falls under the category of live-in relationships or not. So one is section 50. If you remember correctly, I said that for a live-in relationship to be a valid live-in relationship, the society must perceive you as a married couple, or maybe as a couple who has been living together from a good time, from a reasonable time. So this brings me to section 50, which says that this is pertaining to the Indian Evidence Act. Now this says that if the court has to form an opinion as to what kind of relationship exists between person A and person B, the opinion of any person, for instance, your neighbor, your relative, your friend, your colleague, your house help, or any other person, that person's opinion would be a relevant fact. And having said that, the court may allow such a fact to be, such a person to testify what kind of relationship exists between them. And depending upon the facts and circumstances, the court may use this as a piece of evidence if it is sufficiently proved by other evidence on record. So the opinion on relationship by any person, it may become relevant in these cases. Then also, you all might be knowing about presumptions in law. Does any one of you know about this? Have you ever heard about these presumptions? Presumptions of law, presumptions of fact? Anyone? Does anyone has ever heard about presumption of fact, presumption of law, rebuttable presumption of rebuttable presumptions, irrebuttable presumptions, any kind of presumption? Anyone?
Just
Okay, so let me tell you. So, in a court of law, there are a few things which the law wants should not be disputed. For example, if um, if a married couple, if a legally married couple has begotten a child, right, within a period, or within a reasonable time of their separation, or for that matter, when their marriage was in subsistence, in existence, or you may say, just to explain this with an example, suppose X and Y, they are a legally married couple, and they give birth to a child Z. So that child Z is presumed to be a legitimate child of that couple, isn't it? The law doesn't want you to give proof of this thing in the court, right? The law says that we are going to presume that this child is the valid or the legitimate son or child of that couple. All right. So likewise, we have some presumptions. For example, the best example of a presumption which just came to my mind was, in a criminal system, an accused is proved. An accused is, he's presumed to be innocent unless he is proven guilty, unless his charges are proven, isn't it? So
Yes.
we are presuming that
but that principle doesn't apply in common law, because from the moment you are
that
already in
principle.
custody at the police custody, the presumption of innocence no longer applies. It's in civil law that the presumption of innocence applies till you are proven guilty in front of a court of a judge.
Okay, that's interesting. In India, presumption of innocence is still applicable except in the terrorism cases or except in the national security cases. We have presumption of innocence still prevalent. Even in the, has any one of you, does any one of you know about Ajmal Kasab? He was a renowned is a bad adjective. He was a very famous terrorist who was responsible for the one of the attacks in India. He was a terrorist. Does anyone of you know about Ajmal Kasab?
Not me. I don't know him.
Okay. So he was responsible for an attack on in Mumbai. He was responsible for a massive terror attack followed by bomb blasts in India in a large city, Mumbai. So, and he was caught red-handed. All right, while he was shooting some innocent people inside a hotel, he was caught red-handed by the Indian police. But even then, after doing mass murders, even after carrying out such a huge terrorist activity, he was given an opportunity of being heard. He was given legal representation by India. He was given a proper defense, and he was, until and unless his all charges were proven, he was not given any punishment. This is the system that India follows, that you are innocent until and unless you are proven guilty in a court of law, right? So this is the system that we have. This ensures that no innocent person is punished for anything. And this brings me back to presumptions. So presumptions are basically things which law wants you to presume, and for which the law doesn't want you to give formal proof. All right. So in Indian Evidence Act, in section 114 clause A, we have a presumption that in case two people are living together for a long time as husband and wife, in that case, they will be presumed to be a married couple. Now, this presumption is only used when the court wants to order in the favor of the aggrieved spouse. For instance, if the other spouse has left you in a state of destitution, if you do not have any shelter, any food, if you do not have any means to, survive. So in that case, you can go to the court. You can ask the court to order your other partner to give you maintenance, to give you alimony, to give you rights in your property as well, if you have sufficiently established that yours was a valid legal live-in relationship. Only in that case. All right. So I have already told you about United Kingdom. That United Kingdom has a full-fledged Civil Partnership Act which governs the rights, obligations, and the duties of the partners towards each other. It's not like we have in India. In India, we have left it on to the courts to determine, as per the facts and circumstances of the case, if they want to make bound any party or not. And it is not any full-fledged thing. Now, a very important aspect of maintenance, which was also pointed out by one of the participants. So now, just imagine if you have all the parameters or all the essentials of a legal live-in relationship. Now, you want to, and your other partner, your live-in partner has he has maybe left you without assigning any reason, or maybe you have begotten a child from that relationship. So what are your rights? Can you claim any maintenance? Can you claim any alimony? So the protection of women from Domestic Violence Act, that does provide that if any woman who is in the relationship, who is in a relationship which is in the nature of marriage, so such a woman can validly seek maintenance from the courts. Besides this, the laws which are only made for the wives, the courts have interpreted these days liberally to also include live-in partners. So the courts these days, they are ordering in favor of the maintenance of even live-in partners. And also alimonies, which are the permanent kind of settlement which is granted in the favor of wife. So these are also granted. Now comes the question, on what basis this maintenance is awarded, or for that matter, how the court ascertains this maintenance amount. Yeah, this was one of the questions, right? So how the court ascertains this is, we had a recent case, Rajneesh versus Neha. This is a landmark case in which the courts have mandated that the party who seeks maintenance and the party who is to be ordered to pay maintenance, that is the respondent and applicant both, they have to file before the court an affidavit. The affidavit contains all the details of their income, of their assets, of their all the properties, and also their expenditures that they are having. And the court has formulated a really comprehensive and a very comprehensive and a very beautiful affidavit, which and you just cannot evade, you just cannot undervalue your property. That affidavit is designed in such a way that the court, by hook or by crook, is going to take on record what property, what assets, what income you have in your hand, both of you, even the wife and the husband both. Now, once these affidavits are placed on record, the court sees that what is the financial condition of the wife, and the maintenance that is granted to her, that is the main basis or the main consideration for the court is that what was her lifestyle, what was her living standard when she was she was married. So prior to this divorce or prior to this separation, what was her living standard? So she is granted maintenance according to that living standard only. And that is why courts in India have not prescribed any minimum or any maximum number of maintenance. They have left it on to the, the financial condition of the wife, in what kind of condition she has, whether she's a working woman, whether she's a housewife, if she's a working woman, where she's living. If she's living in a metropolitan city, of course her expenses are going to be massive. If she's living in some kind of small city where the expenses are comparatively less, so this factor will be taken care of. And if she has any health issues, if she has any recurring medical expenditure, if she's undergoing any educational course, anything, so these things are taken care of. And again the courts have said that the main consideration is what was the living standard of the wife prior to the marriage, prior to this divorce. So this is the main consideration, and on the basis of this, the court award maintenance. And suppose the court has granted you maintenance, and after that, there is some kind of change in circumstance. For instance, you were all a healthy person, and for instance, you were granted $5,000 US maintenance. But later on, you are diagnosed with some kind of disease which requires good expenses. For instance, any kind of tumor, cancer, or any other thing. So in that case, you can file before the court that there is a change in circumstance, and the court is going to revise that amount of maintenance, and that is going to, enhance the maintenance amount as well. All right. For instance, this COVID, because of Corona or the COVID-19, we have seen that a lot of people, they have lost their jobs, their businesses, they are running into losses. So in such a case, if the wife, or for that matter, even the husband who has been asked to pay for the maintenance, if that person, if there is a change in circumstance from either of the parties' side, you can file an application before the court, and the court is going to revise that amount. And by revision means that amount may be reduced, that amount may be enhanced, or that amount may be, altered a bit. And also, the court has special powers to even stop this payment of maintenance if you have remarried. If the wife enters into a second marriage, in that case, she is not entitled to maintenance from the first husband, because as soon as the moment you get married to someone else, now that person is bound to maintain you. It's not the first husband, because if maintenance from first husband would also be allowed, in that case, the wife would be entitled to maintenance from the second husband as well, and the first one as well, which is not right. So this is how maintenance in India works. If anyone has any question with regards to the quantum of maintenance, please feel free to ask. I will also discuss about adultery. I am just seeing that someone has written in the chat box. Does anyone has any question with regards to how and how much maintenance is awarded, and how the courts decide how much of amount of maintenance is to be given? All right. So I'll just briefly cover. Yeah. Does anyone want to say anything?
Yes, actually, yes. I wanted to find out from you, I think throughout your exposition on the right to maintenance and all those things, I didn't hear of any provision as whether or not the courts also consider when they are granting a maintenance opportunity to one party, whether the person, maybe a child came out during the living relationship between the parties. If there is a child and this child, a provision must be made to this child. Does the court consider the age limit? Because most of the circumstances, the court will say that this person is of age and the person can take good care of him or herself. So there won't be any opportunity or anything made available for the person in question. I don't know if the question is clear. But
not really. So what I can decipher from your question is whether the courts take into account the age of the party while granting maintenance?
Yes, yes.
Okay, yeah. So you are right. So again, for maintenance, what happens is, if you are not a major, by attaining majority, you, I think, understand that there is an age of majority in every country. In India, the age of majority is 18 only for getting married. For males, and for females, it's 21. All right. So now, for availing maintenance, if you are less than, if in case you are a minor,
Mhm.
In that case, firstly, you cannot even enter into a live-in relationship. This is not even valid. All
Okay.
right. Now,
Okay.
for instance, if you are 17 years old and you have entered into a live-in relationship, now the law says if you are a minor, it is the duty of your parents, your father to be precise, to maintain you until you attain majority.
Okay.
So in that case, how can a person who himself is, entitled to get maintenance from his father, how can he give maintenance to someone else? Are you getting it?
Yes,
So
please.
if yes, if for example X is of 17 years of age, he has entered into a relationship with a woman of 24 years of age. So though the woman is major, but that man, he is a minor. He is still a minor. So if the woman is invoking the jurisdiction of the court that I want maintenance from this person, the court is not going to allow this application on two reasons. One, this relationship itself, it is not valid because this person, a person below 18 years or the person who has not attained majority in India is considered that this person's consent is no consent at all.
Okay.
If you are below 18, only your parents can consent on your behalf. A person below the age of 18 years is not considered as a fit person who can give consent for contracts, for marriage, or for any other act in India.
Okay.
Is that right?
Yes.
So in
Yes.
that case, your relationship on the threshold, that is going to be not considered as a valid relationship. Number two, even per contra, let's just consider that the court has taken into consideration this fact that this relationship is valid. But again, how is that person going to give maintenance to that woman? Because this person, he himself is entitled to protection of maintenance under the law. So in such a case, the maintenance will not be allowed. Even if that person is working, this maintenance application will be rejected outrightly until unless that person attains majority.
Okay. Okay. Okay.
Is
That's
this question clear now?
yes, please. It is. Um.
All right. So I think we are also running short of time. I've taken a lot of your time, so I'll just try to, shorten down the further discussion. So, what are the now rights of children who are born out of such relationships? Anyone? Do you think such children are legitimate children, illegitimate children, or what status should be accorded to such children? Anyone?
Yes, good afternoon once more. I am
Good
Kwat
afternoon.
Ambos from Cameroon.
Mhm.
Yes, in Cameroon, children born out of wedlock are called natural children, but the law has given them opportunities to also benefit from properties in case their fathers died. But they have to be recognized in court by ex parte application, what we call in French requête au fin de légitimation des enfants. Because beforehand, it was seen that those children born out of wedlock were a little bit not considered by law. So the legislator had to bring in this ex parte application in order to permit them to benefit from the goods left by their fathers in case they die, so that they should be proper, they should be shared equally within the natural children and the legitimate children. So it
Okay.
is, even though it is very difficult because such students do not find their place in the home. They are not accepted by society, which happens to be a great problem
Right.
in Cameroon today. And we have not yet had adequate laws which can permit them to integrate the society properly. So we are still working on that in Cameroon. I don't know if it's the case in India.
All right. So thank you so much for sharing your views and the law which is prevalent in your country. So in India, such a child who is born out of a live-in relationship, or for that matter, a second marriage also, which though is punishable, the marriage, if you are entering into second marriage while your first marriage is existing, so that is considered as a criminal offense in India. But if you have a child from the second marriage, that child is accorded the status of a legitimate child. The reason that the courts and the legislature in India have given is that every child, irrespective of how he is brought to this world, he has a right to dignity. We cannot, take away that dignity, that right to life from him. And just because the child's parents, they had a defective relationship at the time of begetting this child, only because of this reason we cannot take the dignity of that child or his right to be known by his father's name, or a right to have his mother's company. So a child of a second marriage, or a child of a live-in who is born out of a live-in relationship, a child is considered as a valid and a legitimate child of that couple only. So if the couple is separated afterwards, so that child is entitled to maintain. Just a minute. There is a question. What if the husband doesn't have enough resources? I'll get back to you on this once I am done. All right. So, in case so I was saying, if the child, who is going to maintain the child in this case? So, because the child is considered to be the legitimate son or the legitimate child of the couple, so it is the duty of the father to maintain this child until he attains majority. Doesn't matter he is living with the same woman who has given birth to this child. If he has entered into any other relationship, does not matter. If you have given birth to a child, the law in India says that you will have to maintain him. All right. And then that child will also have right in your property. So he will have inheritance rights. He will have rights in your self-acquired property, in your family property also, and all kinds of properties. He will have all those rights. And the Supreme Court of India has expressly granted the status of legitimacy, and they have said that the right of maintenance to the child who is born out of a live-in relationship is perfectly valid right, and such a child cannot be considered as illegitimate, and we cannot fix bastardity to this child only because of this defective title to the relationship of the father and mother. So with this, I am done with the rights that a child born out of such relationship would have. Now coming on to the question that somebody asked in the chat box, what about maintenance in case the husband is not able to maintain? So by not able to maintain, I would consider two situations. One is when currently he is not earning, and he doesn't even have any property in his name. Number two, currently he is not earning, but he has properties in his name, or he has other sources of income. So in the first case, where he has completely no source of income, so in that case, the court is going to ask some kind of social worker, any NGO. So we have a lot of commissions, we have a lot of institutions in place for helping such women, and the court can provide housing, the court can provide fooding, lodging, and all kinds of such facilities to the woman, to the wife, at the cost of the state. For example, for the welfare of women, we have National Commission for Women in India. And this commission solely works for the benefit of women. And likewise, we have a National Commission for Protection of Child Rights also. So such commissions are specially made with the purpose of protecting women, children, or for that matter, any other specific category of person who are vulnerable. So in these cases, the court is going to ask such commissions, such authorities to intervene and to provide facilities to these people, to such children, to such women. And in the next case, someone has raised his hand. Just 1 minute, I'm about to just finish this answer. So in the second case, which I told you, was that in which the man did not have, any fixed source of income, or for that matter, he doesn't have a salary, but he has a lot of properties in his name. For instance, he has 10 properties in his name, from which he is getting good rent. So I told you that the court is going to take on record the affidavit of the husband and also of the wife. So in that affidavit, there is a column that how many properties do you have in your own name, in your family's name, what is your share in that property, and likewise you have a lot of options. You have a lot of particulars where you which all have to be duty filled by you. So in that case, the court is going to ask you to pay maintenance from that rental income. For instance, you have shares, you have incomes through any debentures, any shares, or any other financial market, any other source other than a fixed salaried source. So the court is going to ask you to pay from that particular source, which comes under the head of other sources of income. So the court is going to ask you to pay from such sources. This is how the courts treat the cases wherein the husband doesn't have means to maintain the wife. And I would say these authorities, just to add to this, the authorities in India, they are doing a wonderful job. These national commissions, these National Commission for Protection of Child Rights, for instance, they have come up with recently a scheme for the welfare of the children who have lost either of the parents to COVID or both of the parents to COVID. So I think India is, one of those countries who thinks about the welfare of children, women, and other people who are more, vulnerable to such pandemic-like situations and other situations. So they are providing a fixed, they are providing financial assistance to such children who have lost their parents to COVID. They are also providing housing facilities, educational facilities. Besides, there are direct cash transfers to such children. A lot of welfare activities are being done for such people, so that they are, though they are orphaned due to COVID, but they are not left out. So the state is doing a lot to protect such children, and I am fortunate to work in this field also. My authority, Delhi State Legal Services Authority, is working to provide ex gratia compensation to such people, to such children, women, parents also who have lost any earning son or a daughter. So, because COVID has been very harsh on all of us, so we are trying day and night to make this post-COVID world a more, more inclusive, a more humane, and a more, welfare state. We are moving towards that, and these associations, these institutions are doing a wonderful job on ground by providing all due assistance to such couples. Now, one of the participants also asked about adultery. Yeah. So what is an adultery? Can any one of you tell me what is an adultery?
Yes.
Yeah. So what do you mean that any ex-person has entered into an adulterous relationship? What do you mean by that?
Please, did you mean adultery?
Yeah, adultery. What do you mean by adultery?
Oh, okay. Per my simplistic or infantile understanding of adultery, adultery simply involves the situation where maybe a man or a woman is engaged in having sexual intercourse with different kind of people. Yes.
Yeah, you're perfectly right. So, adultery in simple words is nothing but a sexual intercourse, a voluntary sexual intercourse rather, between two people who are not married. So, we can say that this is a voluntary sexual activity between two unmarried people, which is which is not out of their marital obligations. Because when you are legally married couple, so you have a right to sexual intercourse amongst other rights. You have a right to enter into such sexual relationships, and you have a right to establish such relationships also. So adultery is when, though you are not a couple, a married couple, but you are you are entering into such a relationship with someone who is not your spouse. For example, X is married to Y, but X enters into a sexual relationship with Z, right? So his relationship with Z becomes an adulterous relationship, because legally he only has the right to enter into such a relationship with his or her wife, with his or her other partner, my bad. So yes, perfectly said by I'm sorry, I don't know how to pronounce your name. My apologies for this. Some scholars define adultery as breach of fidelity among partners. Yes, this is very well defined and very well understood by you also. So adultery is such a thing only. So in India, adultery was an offense until 2019. But India has now decriminalized adultery, and adultery now only remains as a ground for divorce. If your partner has entered into any adulterous relationship, you can only seek divorce on that, divorce on that ground. In 2018, the Supreme Court has, struck down, the Supreme Court of India has struck down the law which criminalized adultery. And what was the major reason for doing so? The court said that for a major person, for a person who has attained majority, we are leaving on to that person to decide with whom he wants to establish any kind of relationship. We do not want to interfere in any person's personal life, because privacy in India is a fundamental right after 2017. In 2017, we had a landmark case of Justice K.S. Puttaswamy versus Union of India, whereby the Supreme Court held that right to privacy is a fundamental right, and it is a part to right to life. So, because your privacy is a fundamental right, now how can you punish anyone, and how can you infringe that person's privacy if he is entering into any relationship with any third person? So in India, this no more is a crime, and this can only be a ground for seeking divorce from your partner. That yes, my partner is in an adulterous relationship, and this is a kind of cruelty to me. So I want to seek divorce on this ground. So the courts are going to give you divorce on these grounds. This is a valid ground for seeking divorce. This is no more a ground for. This is no more a criminal offense. And coming on to another criminal offense, which is bigamy. Do you know what is polygamy or what is bigamy?
Yes, advocate. Yes.
Mm-hmm.
It's
What
bigamy.
is that?
Yeah, with bigamy, like bigamy is when a man is married to, legally married to one woman. You've not divorced that woman, but you've gone ahead to marry a different one. For instance, it is also a crime in Ghana per our Criminal and Other Offences Act in Ghana. It is a bigamy for a man to marry to one man, like one wife, and you've not divorced that wife, went ahead to marry a different wife. You are criminally liable for that act. So that is bigamy.
Yes, you are right. So, bigamy is when you have a perfectly existing first marriage, and while that marriage is existing, you marry someone else without divorcing that person, without separating from that person, or for that matter, if that person is alive, had that person, if that person is dead, so of course your marriage has ended on its own. But if your first spouse is living and you have not if you have not sought any divorce, if you are not judicially separated, in that case you cannot marry anybody else. And if you marry anybody else, this is an offense in India, and this offense is punishable under section 494 of IPC. And it says that section 494 of Indian Penal Code declares that any person who is found guilty of bigamy, he shall be punishable up to 7 years and fine. Now, one interesting question that I would ask to all of you is, now I'll just give you a situation. A is married to B. All right, they have a perfectly valid marriage which is existing. Now A enters into a live-in relationship with C. So can the wife, B, which is of A, invoke the provisions of bigamy to prosecute A? I hope I'm clear. So can bigamy be the charges of bigamy can be brought against the husband? In this case, he has not married, but rather he has not married, but he has entered into a live-in relationship. So what should and how should the courts decide this? Anyone? In this case, the person has not married anyone, but he has entered into a live-in relationship. So can the offense of bigamy be attracted in such a case? Can he be prosecuted? Okay, I'll just repeat this. For example, A is married to B. Okay, their marriage is perfectly valid. They are not divorced. They are not separated. A enters into a live-in relationship with C. Now, can the wife of A, the first wife, the legal spouse of A, can she bring the charge of bigamy against her husband?
Can you hear me?
Yeah, I can.
Okay, this is Deogratias Nheziryayo speaking from Rwanda. I'm an ALISA member. I have an opinion here regarding the judgment I read recently. It was the judgment that was about the breach of fidelity. So then they defined both terms, bigamy and even adultery, and they just showed us that when it comes to such relationships, that goes beyond the normal relationships that people should have. It's like, as we said in the case, A and B had married, but A is having a relationship with C. So then in that case, that relationship, it can be of romance, it can be bringing in, facilitating, helping that person in a way that is beyond the limits. We usually know that the partners should be having to consent to activities that are everyone should be engaging in. They should be consenting as they are married. So when there is no consent for such actions, of course, it is not going to be bigamy, but it is going to be the breach of fidelity that they owe each other. So in that case, it was decided that relationship among the spouses is not limited only to just saying that there is no full bigamy, that the one is going to marry the other person, or there is no sexual intercourse, and we say that we now have involvement of adultery, but then we included, in the case they included even other activities that are bringing in close relationship with the other person other than the partner without the consent of the partner. So then they called it the breach of fidelity, which is also an element to both adultery and bigamy.
Mm-hmm. Okay, okay. I must say you have a really good understanding of legal provisions, and you will be a really good lawyer. Yes. So you have, I think, answered perfectly this question. But the question, the exact proposition that is in talks these days in India is, now this breach of fidelity, this is no more an offense in India. As I just said, that adultery after 2018, it's no more an offense in India. And for charging someone with bigamy, performance of second marriage is essential. Are you getting it? So for bigamy to be attracted, it is important that the person should formally marry someone else. If he is in a live-in relationship, the offense of bigamy is not attracted, because the essentials of bigamy clearly say that a person has to perform a legal and a valid marriage with the second spouse. If he has not performed a marriage, or if that is a defective marriage, by the offense of bigamy is not attracted. But this is one of the loopholes of, I would say, the provisions of bigamy in India, because now that we have decriminalized the offense of adultery, so what would the aggrieved partner do in this case? So this is something which I think, the courts are going to ascertain is in days to come, that any person, by not marrying anyone and just by entering into a live-in relationship, can flout these laws. If any person doesn't want to divorce his first wife and he wants to live with any other woman, so instead of marrying her, he can just be in a live-in relationship and he will not be prosecuted for bigamy. But of course, I am confident that the courts are going to take due notice of this fact, that the rights of the first wife or the first spouse in this case, they will be seriously hampered. And the courts are going to give some kind of progressive judgment on this aspect also. This thing has not come before the court as of now, because this is a recent ruling only of 2018 that adultery is no more an offense. Earlier, such cases were being dealt in under the provisions of adultery only. And bigamy, of course, is not attracted because there is no proper marriage. So with this, I think I have covered almost everything which pertains to the live-in relationship. Now let's just have an open house wherein all of you can just switch on your video modes and discuss anything with respect to the topic of this session, or anything extempore. I think I still have 10 or 15 more minutes, and then it would be my dinner time most probably. It would be 9 p.m. here in India.
Okay, I think Deogratia's hand is up. Can you please go ahead?
Okay, thank you. Can you hear me well?
Yes.
Yeah, I can hear you.
Okay, I liked the conversation that we had about this relationship, and even other conversations. The seminar The session was really interesting. So I've got a question there on the relationship when we talk about the children, their relationship with the parents, what we call filiation under Rwandan law as our legal concept is. Do you have in India, in your roles, do you have statutory limitations to claims of paternity or maternity? You can just help me know if you have such limitations of, I mean, prescriptions. And if yes, should really time limitations pose any termination to the blood filiation? This I'm asking it because I'm facing so many cases here in Rwanda where people face that challenge that they say, now the time has elapsed and then I cannot take action to court to file for maybe paternity or maternity, or I cannot now deny paternity or maternity. Then finally, you end up having obligations that you should not have. And the constitution should be providing that everyone has right to have a family, right to be raised by parents. So then we find a contradiction there. So then I want to know the situation there in India or elsewhere in the part of the world as we have participants here at this meeting. Thank you.
Thank you so much for asking the question, but I am afraid I did not really understand your question. If you could just put it in simple words for me, because there are language barriers and accent barriers also. If you can just, simplify it
if
in
I
a
can
sentence.
attempt to answer his question. If I can attempt to answer his question, I believe in Rwanda we have what is called the Abunzi Committee.
Yeah, you can also just write it down in the chat box so that I can answer it, or you can just orally say. You can orally just repeat this question. Yeah.
Yes, I hope I can use simple words. Then you can understand.
Oh yes, definitely.
We know what we call prescriptions.
And yes, sorry to just interrupt you. If you can just go slow.
Okay, no problem.
Yeah,
I think you know what we call prescriptions in law. Prescriptions.
Yes.
And we know what we call filiation, blood filiation. Just as a child should have parents, maybe both parents, mother and father. Let it be the child born out of wedlock or the child born in the marriage, he or she must have both parents. So then here in Rwanda, some provisions are clear that if a certain period of time elapses, as a child, you are no longer having that right to claim for paternity. The same case to a parent. If a parent for a certain period of time elapses without lodging the claim of denial of paternity or denial of maternity, he by then cannot have that right to institute the proceeding, the claim for denial of paternity or maternity. And when I compare these two constitutional rights of having a family, I see the contradiction. So then I wanted to know the situation there in India or elsewhere, as we are here, if we also have limitations, statutory limitations, prescriptions in their laws. And after that, I need to know, how do you perceive this? Should really the time limitations pose determination to the blood filiation? Thank you. That's how I can make it simple to understand.
Yes. Thank you so much for putting it into simple words. Now I'm able to understand at least some part of it. So what I could understand was that there is a time, there is a specific, prescribed time within which a child can claim paternity or maternity.
Exactly,
in the court of law.
Exactly, that's right. Yes.
All right. So we have a similar provision in India, and if one has to, so the provisions in India, interestingly, they only pertain to the paternity. There are no provisions which expressly grant you maternity, because it is believed that it is always known that who is the mother of the child, right? It is only the paternity which is disputed in India. So that is why the law has only taken into consideration the paternity of the child, because that is always disputed. So when it comes to paternity, it says that this is section 112 of Indian Evidence Act, which provides that if a child is born out of a valid wedlock, by valid wedlock means you people are not divorced, you people are not separated, or if a child is born within 280 days, 280 days of you both being separated, in that case, it shall be presumed that this child is yours. That is, that child belongs to that. He is the legitimate son of that that person only, that husband. Within 280 days, if that child is born, and how this 280 days the legislature has calculated. So they have just calculated it keeping into account if, for instance, a couple has begotten a child today, and if during these 9 months, if they are separated, so what would happen is that they don't have a valid wedlock. So to protect the children who are born during in cases wherein before a child was born, divorce has taken place, death of the father has taken place. So to protect children of in such cases and to grant legitimacy, the law says that if you are born within 280 days of your father being dead, your father being separated from your mother, in that case, it will be assumed, it shall be presumed that you are a legitimate son of that man only. So this is a time limit of 280 days. Now, how do you claim paternity in India? There is no fixed time limit within which you can ask the court to declare you as a son of any XYZ person. I think your question was this only.
Yes,
That
yes.
suppose if I am less than 18. Yeah.
Mm.
Are you able to hear me?
Yes, I'm getting you clearly.
Yeah. So yes. So suppose I'm not saying that this is the law in India. I'm just giving you an example. For example, there might be a rule that in case you want to claim paternity, you must not have attained majority. You must not be above 16, above 15. So any XYZ rule can be there. But in India, we do not have any such law. What provisions are usually used by such children, in case it is in case if it is not clear that who is the father of the child. So in that case, either the mother of the child or that child through mother or any of his legal guardian, if he is below 18, he can file a declaratory suit in the court. And what happens in a declaratory suit is that the court is going to declare that you the child of this child is a valid and a legitimate son of this mother and this father, this person and this person. The role of the court is limited to this aspect, that they are going to declare it. And once your right is declared that you are a legitimate son of this person, automatically paternity is granted to you. But there is no time limit in India within which you can bring such suit for paternity. I hope I have understood your proposition and I have answered it.
Yes.
Okay, so now that you are taking so much of interest in this, I would just ask you one more question. I have written I've done a research. I've done a research on this, so that's why I'm curious to know your opinion also. So now, just imagine in today's world, we resort to so many assistive reproductive technologies. We resort to surrogacy, we resort to these IVF treatments. If you know, these days the children are born through test tubes, IVF, and other methods also, which are not the natural ways of conception. You know about this? These processes of begetting a child.
Yes, we know. We have even a trending case here in Rwanda recently that we had surrogacy case at first time. So you can proceed with the question that you want to raise here. It was a very interesting case. Yes.
Okay. So this is an interesting point in India also. So now we say that only the person who is within a marriage, valid wedlock, only he is going to be the father. Now, the question is that let's take an example of IVF treatment. You know what happens in IVF? So in IVF also we have various categories. In a few cases, when the male partner, if the doctor says that he just cannot, his in case his sperms are not fertile enough to beget a child for a proper conception, in that case you resort to donor sperm. All right, so in that case there is intervention of a third party in this. So now the proposition is that child, what if this donor is not consulted with the consent of the father or the husband, for that matter, right? What if the consent of the husband is not taken before that woman has resorted to the IVF treatment in which the donor sperms are taken? So this is a question which was, recently such an interesting case. It came up before the courts in Canada. So they said that, just 1 minute, let me recall what did Canada. Yes. So what did the Canadian courts ruled out in this case? They ruled that for such children to be a legitimate child of that person, at least that person should be informed, right? At least that person should be informed that his wife is entering into some kind of medical procedure for begetting a child. And if his consent is not taken, in that case, you cannot accord, paternity to him. You cannot attach such kind of paternity to him. Now, for such cases, what the courts have done, now the courts are getting such cases wherein the husbands, they initially they agree for such treatments, they agree for such kind of procedures, but later on, to do away with the responsibility of such children, they say we have not consented. Now, what to do with that child who is in the womb of the that woman? So now the courts are saying that these labs, these the courts in India also, so they have come up with guidelines which says that before you come up with the before you start such a medical procedure, the doctor is going to take on record the written consent of the mother, the prospective mother, the prospective father, and also the donor, because in these cases, in some cases the courts have very erroneously also attached liability of maintenance to the donor, whereas the donor doesn't have any obligation to maintain that child.
Uh,
Can you see me? I think there was some network glitch from my end. I'm really sorry for this.
yes, we can see you. Thank you.
Yeah, yeah. So, in such kind of cases, some kind of obligations were fastened up to the organ donors and also to the testing labs who were facilitating such treatments. So the medical experts, they have cautioned against these things, and they have urged the government to come up with such laws so that they can protect the rights of all four of them: the child, the woman, the man, and also of that donor. This donor becomes mutatis mutandi the surrogate mother also, if we take the example of surrogacy. So in such cases, the right of the third parties have also they have to be protected at any cost, or else these treatments or these procedures are not going to these procedures are not going to last long. So now a very good step that has been taken in India is that the Indian Medical Association, they have come up with guidelines which says that whenever any testing lab is going to initiate any such medical process, they have to take the written consent of both the parties along with the consent of the donor, and also the parties are going to sign and give this affidavit that no liability or no duty is going to be hastened up, no liability is going to be fastened to the the third party, that is the donor. So this is a welcome step in India, but still, as you know, the guidelines are they lack the legal force, and they are not enforced and followed in their spirit properly. So I think we should have a proper bill, or proper, my bad, not bill, a proper act which codifies the rights, the duties, and the liabilities of all the parties in these cases. And what would happen in case of miscarriages, who is going to be liable for this. So we should ascertain all of it, in my opinion. If anyone has anything to add to this, please please feel free to do that.
Okay, thank you. I can come again. It's very interesting that in India you are taking steps recognizing such other medically assisted births. And I have a curiosity question. Can someone engage in such activities like surrogacy just as a business? Does your law accept that? Like, can we as two partners, can they contract with someone else, a contract that involves money, so that we want that person to help us in surrogacy process? Like we provide sperms of the man, and then she gets pregnant in our behalf. She raises our child in our home. Then by the time the baby is born, then she gives the baby to the couple upon a certain payment of an agreed amount of money. Do you have such legal provisions? Thank you.
All right. So again, a very interesting question from you. So these surrogacies are known as commercial surrogacies because these are performed in lieu of some kind of pecuniary, some kind of monetary benefit. So in India, commercial surrogacies are expressly banned. Surrogacies are only allowed in case whenever they are not done for the purpose of any profit or any kind of monetary benefit. For example, if I cannot bear a child, right? So instead of me, my mother, my sister, any of my acquaintance, she can bear a child on my behalf. So this surrogacy is not covered by commercial surrogacy, because this is not in lieu of some kind of monetary benefit, but rather this is because of some kind of special relationship that we share. So such surrogacies are perfectly valid, allowed in India, but commercial surrogacies are properly banned. And we have a huge long history to this, because in India the females have really good fertility rates. So the practice of commercial surrogacies, it was prevalent, and couples from outside, they used to come to India, and they used to beget a child through Indian women. But India recorded so many cases wherein these women, while they were, in their last trimester of pregnancy, they were left as these people did not take any responsibility of the child, and they fled away to their home country. So in these cases, what would that woman do with that child? And what would the government also do with that child? This was a pertinent question. And the thing that we in India follow is, whenever any case pertains to children, so in India we say that follow the principle of best interest of child. When we say the best interest of child, we say that even if there are two views possible in any given case, so you follow the one which is favoring the child, which is in the best interest of the child. So you follow that you follow that way. So in these cases of commercial surrogacy, the rights of children were being violated, and besides the right of the woman who was bearing the child, the rights of such women was also being violated. So that's why commercial surrogacy, it's strictly banned now in India. I hope I'm
thank you
clear
so
on
much.
this.
Yes. Absolutely,
Yeah.
you've answered my question, because I've been recalling the case we had previously here in Rwanda, and that was also the concept of it. We were talking. We just wanted to know if such commercial surrogacy can be permitted, but the judgment was clear that only in a case of friendship, or just as a relationship as the same case to your country. That's how it was. So thank you so much.
Okay, so is commercial surrogacy allowed in your country?
No, it is not allowed. It is strictly prohibited. So then I just wanted to know if it's the common practice to your country.
Okay. Same is the case with India also. Commercial surrogacy is strictly banned in India. Anybody has any other questions, or should we just wind up this session? We had a long 3-hour session, almost 3-hour session today.
Yes, that's very true. I think all the questions that I also wanted to ask you for exhausted everything. Maybe you have to shift it to the next section. I don't know, maybe some of our colleagues have questions, but for me, I don't have questions as it stands now. I just wanted to add something that in answering your question, you've delved into all those areas that I wanted to also come in, so there is no need for me to reiterate or say anything, Yes, thank you.
Okay, so if any of your colleagues have any queries or any questions, please feel free to ask, or else we'll just wind this up.
I think before you wind up, let me just clarify myself. With your last example, which says that party A is legally married to wife B, and enter into a living relationship with this particular other person, So dwelling on that premises, even though we established that bigamy is not gonna suffice in that particular case. So, okay. So in that circumstance, can it also serve as a ground for a filing of a divorce? Because you may mention the fact that one of the main reasons why one can file for a divorce is the adultery. So can this one also suffice, or on that tangent? Yeah.
Okay, so if you know that the repercussions that flow from any personal law, by personal law, I mean the law which pertains to matrimony, custody, guardianship of anything, or succession, inheritance. So these personal laws are these civil laws, right?
Okay.
Are you able to hear me?
Yes.
Yeah. So these are what? These are the civil rights that, for example, if I am married to any person, so I have a right to, I have a conjugal right, and I have a right to his company, and this is my civil right. Is this clear? So now, because this is a civil right, and adultery in India, my bad, bigamy in India, bigamy and adultery, if I compare both of them, adultery, you have a civil right against bigamy also, and you have a criminal right also. By criminal right, I mean that a public right also ensues in case any person marries. So in that case, you have a right to prosecute him and file a criminal case also against him, and you can also seek a divorce on that case. So this way, bigamy is also your civil right, and it also becomes a public right by way of which you can seek a criminal, you can initiate criminal proceedings. But when it comes to this adultery, because it is no more an offense in India, on the basis of adultery, you can only seek divorce. You cannot ask the court to punish a person or to initiate a criminal proceeding because a person is in an adulterous relationship. So this is the difference, that in India, for offenses, we have Indian Penal Code, the IPC, which defines all the offenses under which a person can be prosecuted, and it also prescribes what punishment is to be awarded, who is going to try this case, whether it is going to be the magistrate, whether it is going to be the superior court, sessions court, who is going to be, who is going to decide. Whereas when it comes to the personal laws, as I told you, in India, we are governed by personal laws on the basis of our religion. So if I am a Hindu, I will be governed by Hindu law. And if my Hindu Marriage Act provides that I can seek divorce from someone on the basis of adultery or bigamy, I am allowed to that. I am allowed to take that divorce on that ground. If there is any, for example, Muslim couple or any Christian couple, and their religion allows 2 marriages, 3 marriages, or for that matter, some more marriages, in that case, that person or that couple cannot seek divorce on that ground, but they can prosecute that person under the criminal law.
Okay.
Is it clear now?
Yes, very well understood. Thank you so much. Thank you.
Yes.
Thank you very much, and it's very well understood. Thank you.
Yeah. Is any other question left now? Do you have any more queries?
To my side, there is no any questions because I understood it very clearly. So thank you very much.
Thank you so much for being such a good audience, and for being so interactive. And thank you, Mr. Vice President. I am forgetting your name. If you can just tell me your name once again. So I would like to thank you, and Miss Benedicta also. I think she's not here today. She messaged me that she won't be able to make it because of some prior commitment. So she was in touch with me from the past 2 months for taking up this session, and you all have been a wonderful audience. Thank you so much for your time, and I look forward to having more such sessions in which people from other countries would also, share their views and the laws which are prevalent in their country, so that we have a good understanding of the legal systems across the world. I think Mr. Vice President is on mute. Are you able to hear me?
Sure, sure. All right. Hello? Hello?
Yeah, are you able to hear me?
Yes, please, are you expecting something from me or any of the members here? I didn't actually get your last words.
Oh, I was saying if you can just come again with your name, I wanted to thank you personally by, stating your name.
Oh, okay. Okay.
Yeah, I have been calling you Mr. Vice President from the start of this session. So
All right.
that's why.
My name is James Amporiku. James. So simply.
Okay, thank you so much, James, for interacting with me and giving such a wonderful introduction of mine. Thank you so much for this opportunity. And I sign off from here. If any one of you want to connect with me, I'm there on Twitter, I'm there on LinkedIn also. I'll just share my credentials on the group that we are added to. And I look forward to more such sessions. Thank you so much. Good day.
Thank you very much, Advocate Gandhi. We are so much glad. We are most grateful for having you. Honestly, you've given us a whole lot of legal education that you will have paid a lot of money to get, but because of your selfless service that you've rendered to this noble association, we are very much glad and happy, and we are forever grateful. We are looking forward to having more engagement with you, and may God bless you, for having us. Thank you so much and have a wonderful evening.
Thank you so much. Thank you so much. Thank you so much.
All right then.
Good day.
Good day. Bye.
Hello, Barrister Bhawna. I really thank you for this very wonderful and remarkable time that you give it to us for these dedicated actions. So we don't have anything to say. May the Almighty Allah bless you and your family and wishing you long life and prosperity. I really impressed the way how you dedicate your time to give a clear explanation about some aspect of the law. So thank you very much. I'm Ilyas Lekasu from Nigeria.
Okay, thank you so much, Ilyasu. Thank you so much for such kind words and acknowledging my efforts. This really means a lot.
Wonderful. Wonderful. Then we are signing off. So my name is James Sampo once again. My name is James Sampo once again, Vice President of the African Law Student Association. We are going to make the video available on our YouTube page. That's Outside TV and all our social media handles. Facebook, Twitter, Instagram, LinkedIn, and what have you. Thank you so much, Advocate Gandhi.
Sure. Thank you so much.
Day.
Thank you.
Bye-bye.
Thank you. Bye-bye.
Okay, bye.